Morning, everyone. Foreign person surcharges apply in all states and territories for foreign purchasers and owners of residential property. This presentation will focus on the New South Wales surcharges and recent amendments. When introduced, the original intention for the surcharges was to penalise foreign persons, to make housing more affordable for Australians and to bolster state revenue. The surcharges apply to foreign persons, which include foreign individuals, foreign companies and foreign trusts. In relation to foreign trusts previously, it was sufficient to show that there were no foreign person beneficiaries in the trust. But now, following the recent New South Wales legislative changes, it is more onerous. By way of example, if you are foreign, then stamp duty on an acquisition imposes a surcharge of 8% above normal rates on any purchase based on the purchase price of the property. And for land tax, there's a 2% surcharge above normal rates per annum on the residential property based on the land value. So who is a foreign person? An individual is a foreign person if they're not ordinarily resident in Australia. Importantly, this does not apply to Australian citizens. So if you have a child who is an Australian citizen and they leave to live overseas, marry someone, they remain an Australian citizen and they're not a foreign person for these purposes. We'll get into that a little bit later on because it does impact the treatment of trusts where Australian citizens' children and their spouses are beneficiaries. But repeating, it's an individual not ordinarily resident in Australia. The big issue is foreign persons. So just a reminder, in New South Wales, these surcharges only apply to residential property. And the recent changes only affect discretionary trusts that own or are used to purchase residential or residential related property in New South Wales. The surcharges do not apply to non-residential property. If a discretionary trust has one foreign person as a beneficiary, and that doesn't matter if that's a foreign individual, a foreign company or a foreign trust, then that trust is treated as a foreign person for the purposes of the surcharge. So even if there are no current foreign persons who are beneficiaries of a trust, the trust will be deemed to be a foreign person now, following the changes, unless the trust deed expressly prevents foreign persons from becoming potential beneficiaries, and the trust deed prohibits an amendment to allow a foreign person to become a beneficiary in the future. This means that all trust deeds that are relevant need to be amended. I'll provide more detail shortly. So a reminder, Australian citizen beneficiary is not a foreign person, even if they reside overseas. So if they are a beneficiary, that is not an issue. However, if that Australian citizen, say a child who lives overseas, marries an overseas person in Spain, France, etc., and then their spouse is a foreign person, and potentially their children, if they don't automatically get Australian citizenship, would also be foreign persons, and consequently the trust may become a foreign trust unless the deed is amended. The adverse impact of the surcharge can be avoided by amending trust deeds by 31 December this year. Prior to these recent changes, it was sufficient to avoid the stamp duty surcharge if there was simply no foreign person beneficiaries in your trust, and the trustee provided that you would not give benefits to foreign beneficiaries. However, now it's irrelevant whether there is actually a foreign person beneficiary. or that you've ever made or you propose to make a distribution to a foreign person beneficiary, the mere possibility that you could do so determines that the trust is a foreign person. So there needs to be an express restriction in the deed, and there needs to be no power to change those restrictions. So by way of example, consider this. The Jones Family Trust owns the family home in Mossman for asset protection reasons, and it also owns a beach house in Byron Bay. Mr. and Mrs. Jones are the specified or principal beneficiaries of the trust. Like any modern discretionary trust, there would be an extended class of general beneficiaries who would include the children, grandchildren, and remoter issue, would also include spouses of the children, grandchildren, and remoter issue, including future spouses, would include siblings, nieces, nephews, cousins, companies in which any beneficiary has a share, and trustees of a trust in which any beneficiary has an interest. Mr. and Mrs. Jones have two children, Bobby, who is 8, and Betty, who is 5. So, 3 examples. Because Bobby, the 8-year-old child of Mr. and Mrs. Jones, could potentially marry a foreign person 20 years from now, today, that trust, the Jones Family Trust, will be considered to be a foreign person, simply because of that possibility. If Mr. Jones' cousin owns 5% of the shares in a company that's 25% owned by his English friend, the company will be a foreign person because the English person has an interest of more than 20%. I'll get into this detail later in the presentation. The company is therefore an eligible company beneficiary of the Jones Family Trust, as Mr. Jones' cousin is a shareholder in the company and also a beneficiary of this trust. Therefore, the Jones Family Trust has a foreign person beneficiary, namely the company, and therefore the Jones Family Trust is a foreign person. If Mrs. Jones' niece is a general beneficiary of her husband's family trust, a different trust altogether, which does not include the foreign person exclusion, then the husband's family trust, by not excluding foreign persons, is deemed to be a foreign person. The husband's family trust is an eligible trust of the Jones Family Trust because Mrs. Jones' niece is a beneficiary of both trusts. The Jones Family Trust has a foreign person beneficiary, namely the husband's family trust, and consequently the Jones Family Trust is a foreign person. All of these things are all outside of your control and may not even be within your knowledge, but in each case, the surcharges will apply unless the deed is amended prior to 31 December. So we're talking about trusts where there are no foreign beneficiaries, but future spouses and future children of the children could potentially be foreign persons, not to mention the cousins and the nieces. So every family trust that owns a holiday shack in a discretionary trust in the Hunter Valley, Palm Beach, Byron Bay, the Southern Highlands, or the Blue Mountains must vary the trustee to avoid the surcharge and must do so before 31 December. And any person who owns their family home in a family trust for asset protection reasons also has to vary their trustees. And next slide, Ali. Okay, so when is a corporation or a unit trust a foreign person? The New South Wales legislation follows the Foreign Investment Review Board approach and the definition from the Foreign Acquisitions and Takeovers Act. So what this means is when a 20% interest is held by a foreign person, including a discretionary trust, or a 40% interest is held in the aggregate by 2 or more foreign persons, that trust or company, that unit trust or company will deem to be foreign. So in other words, if there are discretionary trust unit holders who have not amended their deeds to include these foreign person restrictions, they will be a foreign trust and they will be foreign for the purpose of establishing whether the unit trust or the company meets these 20% and 40% thresholds. So let's look at this particularly in relation to REITs and unit trust syndications. So the FIRB test, as I mentioned, applies. So the unit trust will be a foreign person if there is a 20% interest held by a foreign person or 40% held in the aggregate by two or more. If this is the case, then the unit trust or company would be foreign and the stamp duty surcharge would apply, and the trustee of the unit trust would be liable for the surcharge. For land tax purposes, if the unit trust is not a fixed trust, then the trustee is liable for the land tax surcharge. And if the unit trust is a fixed trust, the trustee is not liable and the foreign unit holders will be liable. Discussing what is and isn't a fixed trust is complicated and outside the scope of this presentation, but if you have any interest in that, just let any of the Sydney guys know. There are different rules for Australian listed companies and Australian listed unit trusts. Where you are listed, interest of less than 5% are disregarded when determining whether the company or the unit trust is a foreign corporation, and therefore disregarded when you look at the 20% and 40% thresholds. But if the unit trust is a listed public or wholesale unit trust, you need specific advice and you need to speak to someone in the Sydney ABL tax team or Milton. Okay, so what should REITs and unit trust syndications do? They really need to know who their unit holders are. Property syndications in unit trusts with residential property must check with the discretionary trust unit holders to ensure that those unit holder discretionary trust deeds comply with the foreign person amendments. If not, the unit trust may be considered a foreign person and subject to surcharges if they meet the thresholds. You need to communicate with your investors to understand the nature of their entity. And if the unit holders are discretionary trusts and you've determined that the unit trust is a foreign person, then the unit trust must ensure that the unit holder discretionary trust deeds have been amended to comply with the new requirements. And you also must obtain copies of those trust deeds or deeds of variation, as there is a lodgement requirement. And I'll provide more detail of that later on. If the discretionary trust unit holders do not have complying trust deeds or don't respond, then you really need to seek legal advice, as the deeds must be amended prior to 31 December. Alternatively, if that's all too hard, the unit trust can simply choose to pay the stamp duty and or the land tax surcharge. So what sort of land does this apply to? I mentioned previously it's only residential land. The definition for stamp duty and definition for land tax are slightly different, but for both, residential includes vacant land zoned as residential, land on which there are one or more dwellings, including buildings under construction, land use entitlement, if it entitles the holder to occupy a building or a part of a building as a separate dwelling, strata lots and utility lots. The difference for stamp duty and land tax, and this only applies for stamp duty purposes, is that it will apply also to options to purchase any of the above types of land or interests in land. And generally, residential land excludes commercial residential property, for example, hotels, student accommodation, and aged care. If you have a mixed use property, the Commissioner may reduce the dutiable value and only apply the surcharge proportionately based on the residential proportion. So, what can you do? What do you need to do? So if you look at this flow chart, so does the trust, or in the relevant case, unit trust, own or intend to own residential related property in New South Wales? If not, nothing's required. If yes, You need to review the trust deed to check the trust deed includes the necessary foreign person beneficiaries and trust amendment restrictions. If it does, no further actions required. I should say at this point, most deeds would not include, most off-the-shelf deeds would not include those restrictions unless you had acquired that trust this financial year, as the amendments were known to us. But if it doesn't, then the deed needs to be amended. Where that trust already owns residential property, then you must amend the deed by 31 December this year. If it doesn't and it's intending to purchase, then the deed needs to be amended by the due date for payment of stamp duty on the acquisition. Ideally, you'd do it before signing the contract, but you have until the due date for payment of stamp duty. So just to remind you again that a family trust will be a foreign person unless the deed expressly provides that no foreign person can be a potential beneficiary, and reminding you that wouldn't exclude Australian citizens. And also the trust deed contains an express provision that it can't be amended to allow a foreign person to become a potential beneficiary in the future. Consequently, this necessitates that all existing discretionary trust deeds holding residential property in New South Wales, unless they were created this year, must be amended or they will no longer comply with these requirements and will be exposed to the surcharge both prospectively and retrospectively. So, shock, horror. Ali, next slide, thanks. These changes have a retrospective effect. If your deeds are not amended by 31 December, the trustee may be retrospectively liable for the surcharge. In the case of stamp duty, in relation to all relevant residential dutiable acquisition going back to 21 June 2016, which is when the surcharge legislation was first introduced, and for land tax going back to 2017 and subsequent years, again, when the land tax surcharge was introduced. Also has an implication for succession planning and testamentary trusts. So for those of you who are not aware, testamentary trust is a trust created in a person's will, a means by which they can bequeath property to others. So if you leave residential property in a will, in a testamentary trust, there is some good news. It's not retrospective. So a testamentary trust arising from a will or codicil which was signed on or before 31 December is exempt from the surcharges, but moving forward from next year, the surcharges will apply to all wills or codicils signed from 1 January 2021, unless the trust deed includes the required foreign person beneficiary and trust amendment restrictions in the deed. So hopefully your lawyers, and certainly we, would be able to look after that for you. So what's the Office of State Revenue doing? They're currently sending letters to all discretionary trusts and unit trusts that own land in Australia. Whether they actually capture all of them, I'm not sure if they have all the relevant information, but we've seen hundreds of these letters. In the case of a discretionary trust, they are asking you to lodge a return and complete a declaration that the trust deed excludes foreign persons, and they don't trust you. They want you to provide a copy of that deed. It's got to be uploaded online, and they are checking them. If it's a testamentary trust, you need to lodge a return that declares the trust excludes foreign persons, or upload a cover letter confirming that it was a testamentary trust created by will or codicil prior to 31 December, and provide a copy of the grant of probate where the person's died. And in relation to a unit trust, trustees are required to lodge a return and a declaration that the trust is not foreign, which is not based on the trust deed itself, but based on the unit holders, and upload copies of all of the relevant unit holder discretionary trust deeds showing that the deeds have been amended or that they are complying trust deeds. So fairly onerous for foreign companies and for unit trusts in particular. So in closing, to put all of this in some context, when you consider the changes were introduced so that foreign purchasers of residential property would pay a stamp duty and land tax surcharge to discourage them from acquiring Australian property or to penalise them for doing so, and also intended to make housing more affordable for Australians and bolster state revenue, these changes were not introduced to penalise Australian entities, or so they said. However, the position today has strayed far and wide from affordability and imposing penalties on foreign persons, as was originally intended. You will be pleased to know, no doubt, that these New South Wales changes are more onerous than for any of the other states and territories. Not much you can do about that, but the other states and New South Wales has unique additional requirements that the trust deed must specifically provide that it can't be amended to allow foreign persons to become potential beneficiaries. And consequently, every trust deed holding residential property and relevantly units in a unit trust which hold them has to be amended to comply. Otherwise, will be exposed prospectively and retrospectively to the stamp duty and land tax surcharges. This doesn't apply in other states and territories where typically it works prospectively, not retrospectively, and the requirement to amend the trust deed is a little bit less onerous. So thank you, and looks like there are some questions.
Yeah, thank you, Joey. Some questions from the floor. I think you've touched on this already, is would the land apply to mixed use land that permits commercial and residential use, which I think you've touched on, and also do the amendments need to be stamped and lodged with Revenue New South Wales?
They need to be lodged as part of the declaration, and either you'll be requested to lodge it. So prima facie, there's no lodgement requirement. There might become one in the future. Typically, people are getting letters, and responsively to that, they'll be asked to lodge that declaration. Now, whether that happens this year or next year, it will happen inevitably, but it may not be required to be lodged by the 31st of December, but clearly you must amend the deed and have evidence that it's been amended before the 31st of December.
You did talk about testamentary trusts. What's the effect of a codicil amending a will signed before, where the will is signed before the 31st of December 2020, but the codicil is signed after that date? Does that somehow invalidate the will as being exempt?
I think if you, I really, I might want to take that one on notice. Thank you, Jonathan, for that curly question. But I would say that if the will creates the testamentary trust or amends the testamentary trust, then you should be making sure that the restrictions are included. If it doesn't alter the testamentary trust in any way, it might be safe to leave it as is, but really out of an abundance of caution, I would include the exclusions.
Joey, one other...
Sorry, I might have missed that, but the testamentary trust you need to amend the testamentary, an existing testamentary trust before
existing testament, no. So we've got, you know, there might be people out in the audience who signed a will with the testamentary trust 5 years ago. I'm grateful they're all alive, and the trust operation, you don't need to amend those. If the will was signed prior, or will and or codicil signed prior to 31 December, you do not need to amend. It's only if you change that will after the 31st of December.
But if you do change, so somebody who, you know, is 50 years old and has a testamentary trust in place, but decides in 5 years' time to amend their testamentary trust, they have to include the exclusion then.
Correct. Any time after 1 January next year.
So they don't have to do it before.
No.
Okay.
So there's a window, you know, there's a window where they'll be grandfathered or grandmothered for a relevant period, but a change to that document will trigger the necessity to include the restrictions.
So I have another one here. All sounds too difficult. If you do nothing, are you still retrospectively liable? And
Yes.
please outline extra costs.
Absolutely retrospectively liable. And the cost would be, if there was a relevant stamp duty acquisition from that date in 2016, then 8% extra stamp duty and possibly penalties, not sure, and land tax surcharge 2% per annum. So doing nothing is fraught with danger.
Assuming you have residential property, if you have property which is solely non-residential, there wouldn't be, I assume, any of those additional costs.
Absolutely correct. The whole discussion is about residential property and mixed use, to the extent there is residential within the property. And so going back to what we discussed before, doesn't include hotels, accommodation, etc. If you're not sure if something's residential or not, then people should check in with, say, you, Jonathan, and you can respond.
So we have another question which asks, if a unit trust owns residential property, which in turn has unit holders, all of whom are unit trusts, and that later unit trust down the line has a discretionary trust as a unit holder, what is the situation if that discretionary trust, sort of effectively 2 steps removed from the landholder, is not amended?
Yeah, so you've got to do tracing. So you've got to look at if I go to the unit holder unit trust, that unit trust needs to look at its composition of unit holders discretionary trust. If they take it over the threshold, then it's foreign, and then it being foreign, depending on the thresholds, will determine whether the unit trust landholder is foreign or not foreign. That's getting complicated. You need to give those examples, but you can, there is tracing through. But still, always you need to be subject to the to the thresholds. Once you are, then you're foreign, and that determines your fate up the line.
So we have another question. Is it considered good housekeeping if you have a discretionary trust which doesn't own residential property to still update the trust?
No, I wouldn't. You're imposing restrictions that really I would not like to impose on a normal discretionary trust and maintain the flexibility. So it's unnecessary, only to avert, something down the track. But you just need to be mindful, if you're buying residential, you need to change it at the time, and hopefully your lawyer acting for you at that time would ask the relevant question.
So we have another question about an existing discretionary trust which post 31 December 2020 becomes the owner of residential property. Can the amendment to the trustee to exclude foreign persons be done at the time of the purchase or transaction?
Yes.
Which I think was answered in your presentation, Joey.
Yes, definitely. Yeah. So you either, if you've got it already, then you have to do it by 31 December. Otherwise, you need to do it before the payment of stamp duty or the time when land tax kicks in. But typically you do it before the acquisition and the time you're required to pay stamp duty, then that applies moving forward.
Another one here, Joey. If commercial land was purchased with the purpose to rezone to residential, at what point would the trustee need to be updated? Yeah,
so interestingly, that there can be I'm not sure when you have to amend the deed. That's a complicated question, but there can still be a surcharge based on a voluntary disclosure that needs to be made at the time you convert. So you need to seek appropriate advice at that point in time, but you might become, if you like, retrospectively liable for the surcharge unless you make that change. So the legislation in New South Wales is a little bit different to Victoria, but in Victoria, it's basically if you buy a warehouse and you intend to few years and then convert it to residential, there's no surcharge at the time of acquisition, but at the time you are proposing to embark on that conversion process, you would be expected to make a voluntary disclosure and pay the surcharge unless your deed included the relevant restrictions. So out of an abundance of caution, if you're planning to do that, I would prefer to see the deed amended from the acquisition, not from later on, but it would appear that later on would be adequate.
So we have...
And that's subject to the relevant legislation in New South Wales. I'd probably need to take that on notice and get someone to check.
So I think we're coming towards the end, but we still have one or two last questions. So very quickly, someone's asked, do you need to amend a unit trust deed?
No. It won't help you. It's the underlying owner, unit holder discretionary trust deeds that are the problem. I have seen someone amend a unit trust, but frankly, I think it's unnecessary.
I'd assume also it's fraught with some danger to start excluding a unit holder who is otherwise entitled to benefit from a trust.
Assuming you could even do that, yeah.
Yes.
I think we maybe just have one final question, and then we've run a little bit over time, but there's so many questions, I think we better...
Yeah, last one here. I've got, are these changes likely to be replicated in other states, particularly where other states have foreign person rules extending beyond residential property?
So each state is different. For example, in Victoria, the land tax applies to commercial and residential. So really, each state is going bit by bit in making the amendments. Victoria's made a series of amendments, haven't quite as far as New South Wales, but this surcharge applies in various forms in each of the states and territory for land tax and for stamp duty. But as I said, there are different criteria. So, for example, in Western Australia, if you've got you've got no foreign person beneficiaries, but a foreign person appointer of the trust, that would make the trust foreign. I can't generalise other than to say for acquisitions in each state, you need to take appropriate advice, and particularly in Victoria, where the land tax surcharge applies to commercial, effectively applies to all property, but is really easy to avoid the operation of the land surcharge kicking in. You need to take advice in relation to each jurisdiction.
Okay, well, Joey, thank you very much for that presentation. Judging by the number of questions, it certainly seems as though it's a topic that quite a few people are interested in, and that's clearly why we did the seminar, because it just seems as though it's one of those things that people will, in 6 months' time, saying, "Oh my God, how did I not know about this?" So hopefully it's helped some people clarify their thoughts. And if you've got any questions, clearly give any of us a call. We've been doing a lot of this over the last 6 months already, so we can do it fairly quickly and efficiently if you need any help. Or even if you've just got some questions, happy to help. I will say Joey alluded to it, but there is another hot topic of New South Wales OSR, which is challenging whether or not unit trusts are fixed trusts for stamp duty purposes, not just tax purposes. And they're doing that so as to deny people the threshold on land tax. It's a separate but related topic, and part of a crackdown, obviously, to widen the land tax net. So if any of you have received letters about that, because I know quite a few clients are suddenly receiving them, you can give us a call about that issue as well. And we might even do another seminar on that topic as well. So anyway, everyone have a good day. Sorry we've run a little bit over time, but hopefully that was useful. And I'm sure we'll be in touch with some of you soon. Thanks very much.